Good afternoon. It's David Gilmore here from DG Legal, here to introduce you to this webinar, which is covering guidance for new civil contract holders. So welcome everybody. The seminar is going to be hosted and presented by my colleague Steve Keeling, who I've told many people in the past, in my opinion, is the best ex-contract manager from the legal aid agency, and he's an extraordinarily popular and able member of our team. So welcome everybody. As you might expect, and as scheduled, this is a webinar for 1 hour, so it's only 1 hour, and we are hoping to draw your attention to the key changes in the contract and key areas for new civil contract holders. We are going to provide you with quite a lot of information over the next 60 minutes, and we'll also be providing you with links for further information. Now, we have a lot of people on this webinar, just under 200 people, so therefore we're not able to make this a truly interactive webinar. Otherwise, what is planned as an hour will end up being 10 hours. So a more practicable alternative to having questions during the hour is for you to please send questions to us after the webinar. Now, we would suggest that the email address that you use should be the retainer email address if you are one of our retainer clients. If you are not, please send an email to info@dglegal.co.uk. In our technical settings, we have muted the participants, i.e. yourselves, but if there is a technical error and we can hear you, we will just ask you to remain silent until the end of the webinar. Once we've collated all of your questions, we will write up an FAQ. We will send that to you by email, together with a link to the presentation, which hopefully is being recorded, and further useful links. We'll then get in touch if anybody has any further queries or needs further assistance in relation to this or any other topics. So let me hand over now to Steve Keeling, who will take you through the topic for the next hour.
Thank you, David, and good afternoon. Welcome, everybody. For this session, we're going to cover a number of areas. To start with, we'll look at your monthly reporting and how you get paid. We'll then talk a little bit about how you prepare for your first visit, commonly known as the verification visit, by your contract manager, and then also how contract manager visits will work in the future and what to expect at those subsequent visits. We'll touch upon the key performance indicators. Many of you who've worked under legal aid contracts before will be familiar with most of them. There's a couple of new ones. And we'll also touch upon some of the key changes in this contract from the previous versions of 2013, 14 and 15 contracts. And as a final section, we'll also look at public funding certificated cases where you can go to get guidance on registering on CCMS, using CCMS, making claims, payments on account, billing, that kind of thing. Okay, so first, the basics, your monthly reporting of matter starts and legal help cases. Each month, you're required to report both the number of new matter starts you open, plus any cases closed that you want to claim via the LAA CWA system by the 20th of the following month. For those of you with multiple offices, you'll be expected to submit one entry for each office. You do this via the CWA system, which you can access via the LAA online portal. For those of you brand new to this, the LAA online portal link can be found on the headline page, the home page of the LAA's website. If you are new to the CWA system or setting things up for the first time as a new provider, the LAA's website has several guides to help you understand how to set up and register individuals. The first thing you need to do is set somebody up as a firm sysadmin as their role. Once you have one of those, that person will be able to set up other users. There are several different roles, which again are explained within the guides, and will give different people in your firm access to different parts of the system. We've put the link on the bottom of the page there for you to have a look, and the guides are really quite good. They'll talk you through step by step. They kind of show you a screen, click here, enter into this box, move on to the next screen, that kind of guide. So in your matter starts, reporting your matter starts is about as simple as it gets. You literally need to report the number of matters that you open in each month for the category of law that you have. Managing your new matter starts, however, is a little bit more complicated. You should always monitor the number of NMS you're reporting and using against that which is awarded. You should know what your award is, but if you're not sure, if you have a look at your contract schedule, which is in the CWA system, you should be able to see how many matter starts you've got. Again, there's a quick guide which shows you how to view your contract schedule if you're not sure how to do that. If you open more matter starts than you've been awarded, the LAA will not pay for those matters that you've opened without their authorization. However, you have the ability in the vast majority of cases to self-grant an increase of up to 50% of your allocation. But you must do that before you go over your allocation. You must email your contract manager to tell him or her that you're doing that and receive confirmation from them that the self-grant has been accepted. When it comes to billing legal help matters, that's a little bit more complicated, lots more information required. There are two main ways to submit this information. You'll either directly input it into the CWA system, or you'll have a case management system which produces a bulk upload spreadsheet. And it depends on the case management system whether it will produce some or all of the information that's required. And you'll then be required to upload that information into the CWA system. Within those quick guide links that I gave you before, there are guides available which walk you through how to do step by step either the inputting or the bulk upload spreadsheet. Either way, it's absolutely vital that you enter the correct codes when submitting a claim. It can cause you all kinds of problems further down the line, as we'll see when we come to the contract manager visits. In particular, the most important code, for those of you with categories of law where you've got different levels of fees, is the code which generates the fee that's payable. So for example, in family, your level 1 or level 2 matters, immigration, whether you're claiming legal help or CLR, stage 2 claim, mental health at various levels there. The codes guidance link is at the bottom of this particular slide. This is probably the most important information for anybody who's inputting claims to make sure that they understand and they get that information right. So when you come to reporting legal help matters, you can input claims as they close. So for example, in September, it would have opened as soon as you'd logged on and registered on the 1st of September for you to input claims as you go along. But you won't be able to submit anything until the 1st of the following month. So the first time you'll be able to submit will be the 1st of October. You can only submit once. You can't recall it. If you send it off with it partially completed, you've got more returns. Tough luck, you're going to have to wait till next month to be able to submit those claims. We talked earlier about the deadline being the 20th. That's the deadline if you want to be paid the following month. So for example, if we're in April and you submit your claim on the 21st of May, you'll not be paid when you're due to be paid the first week of June. However, you will be paid the following month in July. If you've nothing to submit, no claims, you must still submit a nil claim. Again, there's a quick guide on how to submit nil claims. A common error I found when I worked at the LAA was firms had nothing to submit early on, and they would not think to go onto the system the following month until they'd have something, and they'd just go and enter the information in the system, not realizing they're actually entering information for the previous month. And by missing that out, therefore, you're always going to be in a system of playing catch up. The LAA will never trigger payments to you because you'll always be kind of behind the deadline of being up to date with your claims. So important to note that. And the other important thing is try not to leave it until close to the deadline, particularly if this is something that's new to you. It's quite common to make errors when you try to send it or upload the report. It can often be rejected because a combination of codes that you've used on one case might not be compatible. You don't always get an immediate rejection. Sometimes it can be a few hours, it can be overnight. So if you're doing this on the 20th, you might not find out until the 21st that your claim's not gone through on time. So I'd really advise you to maybe start looking at submitting this a few days in advance. The other thing is the system gets very, very busy around the 17th, 18th, 19th and 20th. So the system will generally be slower to upload. In terms of billing, you're required to bill your legal help matters within 6 months of the matter ending. If you report matters late, it may result in your contract manager issuing a contract notice against you for being in breach of this particular clause. We'll talk about contract notices in a little more detail shortly. In general, the LAA has not to date recouped funds for low volume breaches of this nature, so it's just the odd cases coming through after 9 months, 12 months. But we have seen them recoup funds for significant or repeat breaches in these areas. Of course, past behaviour is not always an indicator as to how the LAA will act in the future, so it's better for you to be aware of this and be trying to bill everything within the 6 months. It's certainly enough time for you to be able to do that. And finally, if a client returns to you after you've closed the matter, you should reopen that matter within 6 months. You're only able to start a fresh matter after 6 months. That 6-month period reduces to 3 months if, in your opinion, there has been a material change in circumstances. Again, I've given you the reference in the contract spec there, 3.35. If you're unsure, go and have a look in there. There's a little bit more detail about when to apply the 3-month rule. So as I said before, once you send your claim off, that's it. You can't do anything to it. As quite often happens, you'll realise perhaps you've made a mistake, shouldn't have claimed something with the wrong code. The only way for you to change that is to submit a claim amendment form. There are different claim amendment forms for different categories of law. For example, immigration has a standalone one because there's various different information you have to input for immigration. But it's a fairly straightforward form to submit. The link at the bottom of this page will take you to the guidance on how to complete that form and tell you where to send it to. Don't forget as well, if you open a new matter start, for example, say in September, and in December you decide not to claim that matter because perhaps it's gone nowhere, or perhaps you've realised that one of your fee earners hasn't correctly filled out the legal help form correctly, and you decide not to bill that matter, don't forget to go back into the original month that you opened it in and amend your new matter starts figure down by 1. And in that way, your new matter starts allocation will be an accurate reflection of how many matters you have opened. So having made your claim, how do you get paid? To begin with, everyone on a new contract will be set up on a variable monthly payment scheme, otherwise called VMP. That simply means you'll be paid as claimed. So in the example given here, in your first month of business, you report 3 cases, each worth £200 in September. You'll report them by your deadline of the 20th of October, and in the first week of November, you'll receive the £600. Once you've been billing matters for around 6 to 12 months, and you and your contract manager believes you've got an accurate kind of figure to predict what you're going to claim going forward, you have the choice to elect to change to what's called the standard monthly payment, or to stay with the variable monthly payment. But what the standard monthly payment does is it takes your average claim. So let's say, for example, you've been running for 9 months, and over the last 3 months, your average claim has been around about £2,000 a month. The LAA will say, well, okay, we can pay you £2,000 a month going forward now. And what we'll do is we'll just check periodically to see what you actually claim. And if you become underpaid or overpaid within your contract, what we'll do is we'll vary the amount that's paid to you in future months. And there are pros and cons to both approaches here. Personally, unless cash flow is an issue, I think variable monthly payment is the favoured option because it's much simpler to administer from your point of view, and there's no danger that you can get into a position where if your claims fall drastically, you can owe the LAA quite a lot of money. However, if cash flow is an issue to you and your legal help bills are of a significant value, you may well decide that that extra administration is worth it in order to be able to get the standard monthly payment, because of course the standard monthly payment predicts what you're going to claim and pays you in advance rather than in arrears, which you can see the variable monthly payment scheme does. If you're still not sure, there's more information on the payment schemes in clauses 432 to 438 of the spec, and there's a link on the bottom of this slide. Within that, there's some guidance on how the VMP and the SMP schemes are administered by the LAA. You'll also find a table of upcoming payment dates, so you know what date your contract payment will be paid on each month. Now, escape fees can be claimed on legal help matters where your value of your claim is more than 3 times the value of the fixed fee that you're going to be paid. How you go about that is you just submit the case as normal. So let's take that case that's worth £200, and let's say you've done £1,000 worth of work on that. Just submit it as normal, and what will happen is it will go in as a £200 claim. At that point, you then need to be proactive to claim the additional £800. There is no time limit for claiming, so you can do it straight away, or you can do it 12 months down the line if you like. The way in which you do that is you complete what's called an EC1 form and send that along with the file to the LAA. The LAA will then review the file and they'll do a quick check on things like evidence of means, check the matters in scope, check there's sufficient benefit to the matter, etc. And they'll also check that the time that you're claiming that you've worked on the file is reasonable and is evidenced by way of file notes. If the LAA agree with you that that case is worth £1,000, they'll then credit you the additional £800. If you're on VMP, that £800 will be added to your next contract payment after the LAA have processed your EC1 form. If you're on standard monthly payment, you won't receive the payment as a lump sum. All that will happen is your overall contract balance position will be inflated by that additional £800. So if you were in a position where you were £200 overpaid, it will change you to being in a position of £600 underpaid. But you won't necessarily see a change in your payment because you'll only get a change in your payment at the point that your overpayment or underpayment position is of a significant value. Again, that kind of highlights, I think, how complicated the SMP scheme can be compared to the VMP. And again, a link at the bottom of this slide gives you guidance on the actual EC1 form claim that you send to the LAA. Okay, so in the first few months of your contract, you'll likely receive a visit from your CM. I know already from some of David's clients that contract managers are being in contact, setting some visits up for late October, early November. These are generally called the verification visits, and their primary objective is for your contract manager to check certain contractual requirements. First of all, that your office exists, you are where you say you are, and that office meets the contractual requirements. Number 2, that you have employed the supervisors you said you're going to employ, and that you meet the supervisor ratios within the contract, plus any other remaining outstanding verification issues. While the contract manager's there, the other thing that they'll generally tend to do is have a quick look at those very first few files that you've opened, or have a look if you've actually managed to close any files in those very early months of the contract. And this is setting the scene for the way in which your CM visits will be managed in the future. Failure to comply with any of those verification requirements at 1 to 3 will likely see your contract terminated. If there are any errors found within the opening and closing of files in those early months, it's likely that your contract manager will issue a contract notice and come out to visit you again within a period of a few months, just to check that you're not making the same mistake again. So let's touch on some of those areas in a little bit more detail. Your office, vast majority of contracts require a permanent presence, so your office must be open or accessible to clients for a minimum of 7 hours, between 8 AM and 8 PM, every Monday to Friday, barring bank holidays. And there must be a facility to make an appointment for any member of public calling in during those opening hours. The office itself must be suitable to meet the needs of your client and staff and meet all relevant health and safety legislation. You've got to have a secure location which protects your client files and their confidentiality. You must have waiting facilities, and you must have at least 1 private interview room. If you're in the position of being in an office share, the CM must be satisfied that it's clear to clients at all times who they're being dealt with within that building. In terms of supervision, I would urge you to read those clauses at the bottom, 210 to 228, for all the supervision requirements. This will be an ongoing area that the contract manager will be looking at. The key things that they're looking for is that you meet the supervisor self-declaration. So you'll all have had experience filling those out as part of the tender verification. This is something your contract manager is going to ask you to complete every time they come out to see you, and they'll ask you to refresh it with updated cases Usually those cases, in the vast majority of cases, must always be from the last 12 months. However, there are some extenuating circumstances where you can go beyond that 12-month period. There has to be at least one full-time equivalent supervisor for each category of law. And when you add up all of the fee earners and supervisors, there must be a maximum of a 4-to-1 ratio, or 1-to-4 ratio, sorry, of supervisors to non-supervisors. Now there is full-time equivalents. If you've got 1.5 supervisors FTE, they can interview a maximum of 6 FTE non-supervisors. That applies per category, and supervisors can only supervise staff across a maximum of 2 offices. So if you have got lots of multiple offices, you need to make sure you haven't got one supervisor covering more than 2. When it comes to your contract manager looking at your files, all areas of contract compliance are up for grabs when they're looking at the files, but their main checklist of things to look at will be evidence of means, making sure you've done the calculations correctly, you've got the right evidence on the file. They'll look at scope and sufficient benefit to make sure this is a matter that should be claimed. As we've touched on before, they'll look at the codes which determine the value of the payment are correct. They'll look at disbursements, are they evidenced on the file? Anything over £20 that's not a mileage claim must have a voucher on the file. They'll look at recurring clients, so this is where you've got multiple matters open for a client at concurrent time, or within 6 months of each other, making sure, for example, that you're not opening a matter where the client has returned within 2 or 3 months' time. So, for example, in family cases, generally speaking, you wouldn't have 2 matters open for a client unless it was a private law and a public law matter, or unless a private law client perhaps had 2 different family relationships, problems on the go with both of that. And finally, form completion is correct. Key one here, for example, is your legal help forms, making sure that all the right boxes have been ticked, that the client signed and dated the form. Usually a problem with a form such as that will result in a file being nil assessed by your contract manager. Claims made for files which can't be produced will also be nil assessed. Perhaps not a problem, generally shouldn't be for you in the early years, but looking forward into subsequent years, if your contract manager is calling files from 12 months ago, etc., it's important that you're able to retain those files. If you're getting clients that are transferring out to other solicitors, it's usually a good idea either to photocopy those key parts of the file or make sure you've got an electronic record should the LAA come back to look at your file in future, or at the very least get an undertaking from that new solicitor to release the file should it ever be subject to an LAA audit. Where issues are identified in any files, the LAA are likely to issue a contract notice, and that usually will come with corrective action. So, for example, if your contract manager looks at 5 build files on your first visit and says you haven't completed the legal help form correctly on one of those files, you are likely to get a contract notice. Contract manager will then say, I'm going to come back out in a few months' time and I'll have a look at all your files again and check that you're now getting the legal help form signed correctly. There is generally a zero tolerance approach to any errors, even for new contract providers. There is some minor flexibility within the process. For example, if you just recorded an outcome code wrongly, but it not affected the value of the claim, then I wouldn't necessarily expect you to get the contract notice for that. We'll make an error which causes the claim to be nil assessed or the payment value to be different, you're almost certainly going to get the contract notice. So in terms of subsequent CM visits, you should all receive a minimum of 1 contract manager visit each year. The LAA will say if you're multiple office that every office should be visited at least once during the contract period. Some CMs, however, wish to visit separate offices more often. I've seen some CMs go to every office every year. It really seems to be up to the individual CM. If issues are found on your files when they visit, or if you have a particularly large fund take in a given category of law, or you have multiple offices and multiple categories of law, you're more likely to be visited more frequently than once per month. If a contract notice is issued, your contract manager should generally follow this up within 6 months. Failure to correct that same issue will see a repeat contract notice issued. Now, your contract manager visit is pretty much the gateway audit, if you like, in managing an LAA contract. So almost certainly, I think other audit activities, for example, an on-site audit by the audit team, or a contract compliance audit where they pull your files into the office to have a look at them, may generally lead on from a contract manager finding issues when they're out on site. By and large, if you do well and you pass your contract manager visit, the LAA tend to leave you alone unless something obvious springs up in the management information to want to come out and visit you more often. Where you do receive contract notices, there's a clause in the contract which states, it's actually standard terms 24.1. I just see on the slides I've missed off the reference, so we'll pop that into the presentation when it comes out to you later on. The sanctions may be applied whether there are 3 notices against the same clause or 6 notices just generally across multiple clauses within any 24-month period. Now, quite often some providers see this as a 3 strikes and you're out, if you like. I want to stress it's not a formulaic process. So if a contract manager comes out, finds an error with 1 file, does the same thing for 2 more subsequent visits, it doesn't automatically mean that you're going to get sanctions. The LAA are obliged to look at the picture as a whole. So for example, if you'd had problems with 50 files on visit 1, 40 files on visit 2, 30 files on visit 3, you may well have a sanction against your contract because the LAA will say, we're finding multiple problems, you're just not learning from the previous visits, we need to take more drastic action. In that example of just a couple of errors or 1 error at 3 subsequent visits, it's very unlikely you'll get a sanction. You'll probably be given at least 1 more bite of the cherry at that stage. So in terms of the contract manager visits subsequent to your first visit, what to expect? Well, the review of files will be the main part of a contract manager visit. Because you'll have more of a caseload, your contract manager will look at the information that you've submitted via CWA and will provide you with a closed list of files I wish to see. They'll normally give you at least 7 days notice of that list in order that you can pull files out from on site if you store them off site, for example. Your contract manager will also ask for a sample of either open files or files that have just been recently closed and should probably still be on your premises. And the reason they do that is twofold. One is to check that there's no significant difference between what they're seeing on the files where you've been given advance notice of what they're looking at and what they're actually seeing on the files that they just pick on the day. But also it's to test that the files are actually there and that there's no hint of anybody kind of making up files, making claims to clients that don't exist, etc. In addition to looking at your files and going through those supervision requirements, which we talked about before, the visit will also usually cover the following areas. Your quality standards, so your contract manager will have to see that your Excel or SQM accreditation is still up to date. They'll ask to see a copy of your professional indemnity cover to make sure it's valid and it's at the right level. They'll have a look at your KPI performance, discuss that with you. We're going to talk about key performance indicators shortly, in the next slide, in fact. They'll review your payments on account information. So if you are doing certificated cases and you are claiming payments on account, the LA will be looking at the value, the level of your payments on account, and maybe wanting to ensure that you're operating that system within the rules. They're likely to ask for your latest audited or certified accounts on the visit. Primarily, that's just to see that they're there. Again, if you've got a very high payments on account level, that's potentially money that's owed to the legal aid agency, or perhaps you've got a contract balance on the SMP scheme where you owe the LAA a lot of money. Your contract manager might start asking more detailed questions around your finances. And finally, you'll be asked to provide an updated staff structure, and there'll be inquiries made about any constitutional changes to the firm, change in partnership. Have you changed, for example, from a limited company to an LLP, etc. Okay, so as I said before, we would talk about key performance indicators. There are 7 in total. Most of these are the same as they were in the previous contract, but there has been 1 or 2 amendments and changes, so we'll go through those now. The first two, KPIs 1 and KPI 2, are to do with assessment reductions where you're not being paid at a standard fee. So KPI 1, where you are sending escape fee cases in, and the LAA perhaps look to reduce the value of what you're sending in, that will be recorded. So for example, we used an example of a case where you had £1,000 worth of profit costs. If the LAA looked at that and said, well, no, we only think there's £800 payable here, you would have a 20% reduction against your claim popped into your figures. KPI 1 is generally measured over a minimum of 10 cases, and the target is to stay within a 10% assessment reduction rate. KPI 2 is very similar, but it looks at your license work, so what you're claiming on your certificated cases versus what the LAA actually pay you after they assess the case. Slight differences here, the target is 15% to stay within, not 10%. Also, the minimum number of cases changes. They can measure this over 5 cases rather than a minimum of 10 cases. By and large, the LAA will look at a 3-month period, but will extend that out up to a maximum of 12 months if they need to do so to capture the minimum number of cases within the performance data. KPI 3, this has been in the contract, in the previous versions of the contract, and basically says where you're claiming standard fees, you still report your profit costs. The profit costs you report on average should be within 20% of the standard fees. So again, if your average case is £200, then your average profit cost should be £160 or more against those cases. That's KPI 3A. For 3B, it's a similar kind of wording, but this relates to family licensed work where you pay the standard fee. Now, this is something, as I said, that's been in the contract for a while. I've never actively seen the LAA pursue this, but as I said before, just because they've not pursued something in the past doesn't mean that they won't turn attention to it in the future. But for now, I would say it is one of the kind of lesser key performance indicators compared to the others. Your key performance indicator 4 is rejection rates for license work. So this looks at both your applications on CCMS and the claim rejects on CCMS. And for each of those, you have a maximum reject rate of 5%. Now, a reject is where the LAA return an application or a bill to you because of a technical problem with the information you sent to them. So you put the wrong information in, you've not answered the right question, something's missing, not ticked the right box, that kind of thing. KPI 5 looks at refusal rates for applications for license work, and a refusal is where the LAA turn down your application on the grounds that the client isn't eligible, whether that be evidence of means or whether that be the interest of justice. The refusal rate target, if you like, is to stay within 15% now, not 5%. Now, of these in the past, the civil bill rejects figure, that's actually been reduced down from 15% to 5%. The logic behind that is because you're now doing things electronically. It's much harder to not tick a box or not sign a form. That's generally been one of the most pursued key performance indicators by the contract managers. Application rates for rejects and refusals, not so much in the past, but the fact that they've now put this in with the same one may well give us an indication they're going to start looking at this in a bit more detail. And finally, KPI 6 and 7 won't apply to the vast majority on here because they apply only to clinical negligence or actions against the police, actions against detaining authorities. If you do have one of those categories of law, both of these look at license work and give you a substantive benefit target for investigative work and also for post-investigative work. Now, in terms of key performance indicators overall, not meeting a key performance indicator won't in itself lead to a contract notice or a contract breach. What it does do is it leads the contract manager to have a conversation with you to find out why perhaps not meeting the target as set. It might drive your contract manager to have a look at a particular way you're dealing with things, your processes. It might drive them to have a look at your files themselves, for example, if the fixed fee ratio is very low. Is that indicating that you're doing a lot of very simple cases? Perhaps there's a problem with sufficient benefit on some of these cases. But of itself, it shouldn't necessarily lead to a contract notice, but it may well do. In terms of monitoring your key performance indicators and all other information the LAA hold about you, the LAA have something called a provider activity report. This is basically a report where all your key management information is stored. And the LAA should be sending this to you quarterly. So if it's not something that you receive from them, you should contact your contract manager to make sure you're on the list to get it sent to you. But in between times, if the LAA are coming out to visit you 6 weeks after you got your last one, you can request it from your contract manager at any other time. It's one of those kind of click of the 2 buttons to produce a report and send it to you, so it shouldn't cause your contract manager any bother. The kind of information on there is it'll tell you what civil contracts you hold, it will tell you how you're doing against your new matter start allocation, it will tell you how much fund take you're having against legal help, against certificated cases. And as your contract starts to progress over years 1 and 2, it will show differences whether you're increasing or decreasing your fund take. If you're on the S&P scheme, it will tell you if your contract is overpaid or underpaid and by how much. It will give you your performance against all of the key performance indicators. And where you're claiming payments on account on certificated cases, it will give you your UPOA position. UPOA standing for unrecouped payments on account. There'll also be a box on there which gives information about any other audits that have taken place. So for example, if you had a peer review, what the score is, if you've had any contract notices or sanctions issued within the last 24 months. So at a glance, your contract manager can see where you stand on the number of notices you've had. Really important document. When it does come out, it comes out with a guidance document telling you how to interpret the figures that are on there. If you do get one and you're unsure of it, if you're a retainer client, then obviously contact DG Legal's office and you contact and we can talk you through what it means. But when a contract manager comes out to visit you, this is the first thing they look at. This is how they start to shape what they want to talk to you about and maybe what they're going to look for in your files. It's a really important document. Now, I'm going to assume, obviously, that most of you have worked under a legal aid contract before. So very briefly, just want to point you towards some of the changes in the 28 contract compared to the previous versions of the contract. The LAA has published 3 sets of training on its civil contract pages for 2018. And those are actually the bottom 3 links, on that page. The first one is contract changes in general, so that will look at the standard terms and the general contract specification that applies to everybody. The second set of training is contract changes in the category-specific specifications. So again, if you've got immigration, mental health, family, etc., public law, go and have a look at that and have a look at what applies specifically to your category of law. And then there's also a new provider training, which will give you some useful contacts and links, much like this particular training. There's quite a lot in there, so obviously within the confines of a short training session, we're unable to go through things in a great amount of detail, but we have highlighted some of those key changes in the general changes to the spec and the standard terms. The first one we've highlighted is novations and constitutional changes. If you're changing your status as a firm, for example, moving from partnership to LLP, or if you're a partnership of 2 and you take on a new partner, and there's therefore more than a 1/3 difference change in the partnership, you'll have to have your contract novated. At the point of novation, you'll be required to revisit all of the rejection criteria that were contained within the tender document. So for example, if the new partner that you're bringing on board perhaps has had difficulties with HMRC, owes them money, etc., you will need to go through the process of deciding whether that then changes an answer that you gave at your tender. If it does, there are 2 sets of rejection criteria. There are those that will automatically prevent you from having a contract and they will see your contract terminated. But there are others where the LAA may be open or will be open perhaps to continue with the contract, but you must flag them to your contract manager and have discussion with them before you make the change. Of course, this isn't a change to what's in the previous contract, but if you do make a constitutional change, you are required to let your contract manager know in advance and get the LAA's authority to proceed with that change. The second one I've highlighted is to do with the instruction of in-house or external advocates. So for years, the LAA contract has been silent on this, but they're now stating that you must provide certain information to the client when instructing an advocate, even if you're just passing them off to an in-house advocate. That that must include, for example, details about who the advocate is, what their skills and experience is, why you think they're suitable for the case, and making it clear to the client that they have a choice over the instruction of the advocate. This is something that went into the standard terms in the crime contract about 18 months ago. We have seen a proportion of contract managers, say about 50% now, actually asking to see firms' client care letters to make sure that they are providing this information to the client. Very often crime firms that I've seen are sending out the printed bios from the QCs online along with a letter and saying something like, you need a barrister, we propose to use Joe Blogs, here's his printout from the bio, we've used him in the past in these types of cases, found very good, but of course let us know if you want us to consider somebody else. Generally speaking, that's about the simplest way to meet that requirement. Another new requirement is that you're required to pay all third-party invoices connected with legal aid cases within 30 days. And that's just reflecting the government's guidance on payments to small businesses. Realistically, the only way that's going to cause you a problem, I think, is if somebody complains to the LAA, someone like council, for example, that you're not paying on time. There are some changes to the IT requirements, but generally they're signalling possible future changes. So the nub of what it says in the new contract is that with 3 months' notice, we can require you reasonably to be able to interact with any electronic systems that we might want to introduce. So something called the government secure system, which may come into being as a contract requirement at some point in the future. And of course, there are data protection clauses, and those data protection clauses have been changed to reflect the change in legislation with GDPR coming into effect. The LAA have never really gone there in terms of data protection in the past, but we do hear that they're likely to start auditing your processes and procedures to make sure that you are GDPR compliant at some point in the future. So if it's not something that you've addressed yet within, for example, your office manual, it will be a good idea to make sure that you are on top of that for those future LAA visits. There's also been a change to the delegated functions. That's been removed from the contract now, and delegated functions are at the discretion of the Director of Legal Aid Casework now. In reality, most delegated function work will still be approved, you can still continue with it, but it will exclude most types of judicial reviews, exceptional case funding, and wider public interest cases now. And another key change, the final one that we want to flag to you today, is use of interpreters. The LAA have said within those clauses 247 to 251, you can now only use interpreters that hold a certain type of qualification, and those qualifications are listed within the contract spec. And have also said that at some point in the future, they may move to an approved panel of interpreters, so something that you need to be aware of for future perhaps. Now, like I say, there are lots of changes in there, and there are quite a lot of changes to category-specific areas, particularly immigration and mental health. And also, if you do judicial reviews, the delegated functions training is worth the read. So I would urge you to go and have a look at those links, run through it yourself, make sure all your key staff are aware of those changes. And the final area we're going to cover today is just some brief guidance on public funding applications. So for public funding applications, you don't use CWA, you use CCMS. But that is accessed via the LAA portal, online portal, which you can find on the homepage. Now, there's one link that's the most important link, that first one on there, the ccmstraining.justice link that you can see. All user guides can be found on there, and access to training sessions on how to use CCMS can be found on there. The quick guides are really good, just like those CWA quick guides. They're just a series of screenshots which say click here, click there, move on to the next page. So very easy to use, and they're broken down into 4 areas. One is a general area, how to navigate your way around CCMS, and that will include all the quick guides you need on how to set people up as users and how to restrict access to certain types of fee earners, etc. And then the next 3 sections will look at making an initial application, how you manage a case throughout its life, and then closing cases and submitting bills. Now, at this particular point, I'm going to highlight one particular quick guide, which you'll find in the Making an Initial Application. And it's a guide called the One-Step Substantive versus Emergency Process. There are actually two guides, sorry. There's the one-step process and there's the two-step process. So the one-step process, as you might imagine, is where you apply for the emergency certificate, but also apply for the substantive certificate at the same time because you've got all the information that you need. Quite often, you'll find you're in that position with Special Children's Act cases, for example. If you are doing a one-step process, new users to CCMS almost always make this mistake. They just put one proceeding in for the scope of the certificate. If you're doing the one-step process, you must put at least one proceeding in for an emergency certificate and at least one proceeding in for a substantive certificate. If you don't do that, the system will automatically allocate the scope to the emergency certificate and you'll be granted your emergency certificate. And you'll sit there thinking that your substantive certificate is in the waiting list and you'll receive it 6 to 8 weeks later. But actually, because you haven't added that second proceeding in there, it won't flag anywhere, it'll just be sat in the system. 8, 9 weeks will elapse, your emergency certificate will run out, you'll ring the LAA saying, where's the substantive certificate? And they'll say, you've not applied for a substantive certificate, and you go back to square one in terms of having to wait for the application. So really important, if you're unsure of doing that one-step process, make sure you have a look at that quick guide. It's really well done, that guide, because it's a common area for mistakes. And that will talk you through step by step how to make sure you get that right. In terms of public funding application, there's lots and lots of guidance. I've tried to select some of the key ones. Guidance on representation and proceeding codes, there's a link there. And then also one on the claim codes and the outcome checklist that you need to complete when submitting your bill on CCMS. In terms of looking at assessments, there are 2 documents online which give you guidance on what can and cannot be claimed. The cost assessment guidance is the one that's written for you, the providers. The electronic handbook started its life a few years back as an internal guidance, but actually at some point someone in the LAA thought it might be useful to produce this as external guidance yourself. I find the electronic handbook the easy one to navigate. But you've got both links there, have a look at them. If you're unsure, for example, what you should be recording on the file, or how much time you can claim for a specific type of activity. But be aware, neither document has yet been updated to reflect the 2018 contract. We do expect it to be updated. If past behaviour is anything to go by, we may well be several months into the new contract before that's updated. In terms of public funding applications, to help with your cash flow, you can make payments on account claims, and they fall into 2 categories, profit costs and disbursements. So in terms of profit costs, you can choose 2 occasions during a 12-month period to actually make a request for payment on profit costs. Some firms prefer to do that every 6 months. They'll diarise it to make sure they don't miss opportunity to do it. Other firms will kind of leave it leeway to the caseworkers. They'll know when the best time is for them to do it. For example, there's a series of conferences and hearings coming up. That's the best time to maximise when you're going to get your funds in at the earliest stage. Disbursements, there's no limits on them. You can just claim for them as and when they come up. With profit costs, you can claim up to 75% of your profit costs. With disbursements, you can claim 100% of them. If you're unsure how to claim your payments on account, if you go to those CCMS guides we talked about before, have a look in the managing life cases. There's 2 or 3 in there which will talk you through how to do that. But it's a fairly simple process. Of all the kind of processes within CCMS, it generally is one of the more simple ones. Just be aware, if you are building up your payments on account and there are large amounts outstanding, this is something that your contract manager will want to review with you each time they come out. In particular, where you build up large amounts of payments on account or large amounts on cases that are open for 2 years or more, or amounts that are large relative to what your fund take is, you'll trigger a review of your payments on account by your contract manager. And when I say trigger a review, they'll probably have a look at a few files, want to make sure that you are staying within the rules, claiming with 75%, making sure, for example, when there's no claim on the fund, that you are reporting the cases within a reasonable time period so that the LAA can recoup any payments that are made to you, that kind of thing. Just to give you an example of how this is kind of risk assessed, where your payments on account are 75% or less of what you generally tend to claim over a 12-month period, you'd be considered low risk. 75% to around about 125% medium risk, 125% plus you start to get into higher risk category and you're more likely to be audited. Okay, a bit of a whistle-stop tour, I appreciate that. There's so much information to cover. I could probably run a 2-day course on this and still not covered everything. As David explained earlier, with the number of delegates we've got, it's almost impossible to take Q&As, but I'm sure many of you do have questions. So what we'll ask you to do is that you email those questions to the email address you can see on your screen now, info@dglegal.co.uk. And if you could ask you to put new contract training in the header, just to help the administrators here just sort them out from the other emails that come into that. If you can send those questions in this week, by early next week, we'll collate those into an FAQ and provide the answers to those questions. And at the same time, a copy of the presentation will be made available to you. And I'll also provide a useful links guide. So that will contain all of the links that you've seen within the presentation here today, but will contain a lot more useful links as well. For example, where to find the rates that are payable within the remuneration regulations. If you do decide after this and the FAQ that you need some further assistance, if you're a retainer client, contact your usual contact at DG Legal. We'll be able to answer any simple questions or be able to talk to you if you want some more detailed training or assistance with any area. And again, if you're a non-retainer client and it's something that you're interested perhaps in doing some staff training, contact DG Legal by phone or email and we can talk to you about some of the possibilities we've got. And finally, the last thing I'll say to you, if there's one thing you should do after today more than anything else, it's sign up to the LAA e-alerts. Those of you who've worked in the contracts before may well have signed up before. This is the LAA's main method of communication. We'll always tell you when anything changes, any contract law, the forms are changing, etc. And it's the best way to keep on top of things. So make sure you sign up to that when the presentation comes out to you. Okay, well, thank you very much for listening, and I look forward to receiving any questions that you have. Thank you. Goodbye.